Como vai?
Bem,
Bom, prazer te ver
obrigado pelo
aqui.
convite. Sim, obrigado aí.
Aqui. Hi, Professor Trubek. How's it going? We can hear you. You're mute. You're muted.
Desculpe, eu estou muito bom, gostando do projeto, aprendendo muito coisa sobre o Brasil por causa deste projeto. Voltamos eu e o meu colega Sofia, voltamos à história dos décadas de 60 e 70 e a minha papel no desenvolvimento do direito no Brasil. Muito gostoso.
É uma linda história, com certeza. E como o paper do professor Fábio mostra, uma história de sucesso, eu acho. Uma rara história de sucesso. Bem, yeah, now indeed I'm going to switch to English because we're welcoming our new participants, Gabriel Fuentes Puelles, Marcelo Alvarado Lincopi, María José Jara, whom are the beneficiaries of this program. And before starting, I would like you guys to please introduce yourselves. There are two another students who are admitted to our program who are not connected yet. I hope they will do so as soon as possible. So, Gabriel, could you introduce yourself in Spanish if you want, in español?
Hola, or hello. Well, my name is Gabriel Fuentes. I'm sorry if we can't turn on my camera because I'm currently with some medical problems. I have an operation on my knee, so I'm with some medical, medical problems for general. But I'm here in Seoul. I'm here. Ahora I'm going to switch to Spanish because I don't know too much of English. So muchas gracias por integrarme al curso. Para mí es un agrado. Como les comentaba, tuve una operación recientemente, entonces estoy con muchos cuidados médicos actualmente acá en mi casa porque no me puedo mover y qué sé yo, pero sí estoy acá en alma, como decía, también en mente, en conocimiento. Particularmente mi interés de haberme unido a este curso es porque yo ya había estudiado Derecho en algún momento, si bien abandoné la carrera y me cambié a Administración Pública, igualmente ahora estoy haciendo un magíster en Criminología y Gestión de la Seguridad Ciudadana, donde reforzamos muchos de los contenidos que yo ya había aprendido en el pregrado y que ahora quiero seguir aprendiendo a través de este curso y a través de todos ustedes como profesionales. Mis investigaciones están ligadas particularmente a ciberseguridad eh, y al impacto de las nuevas tecnologías en la investigación penal. Eso más que nada.
Muy bien, buenísimo. Nosotros le escribí un correo sobre después lo que sigue en asignarle un mentor. Yo he conversado con el profesor Fábio, que dijo que en el futuro quizá pueda hacer una one-on-one contigo, como una conversación, pues que es un especialista, sobre todo que ha estudiado el caso, el uso de cómo se dan la transferencia de datos en el caso de la Lava Jato, la Car Wash Operation. Entonces, espero que puedan conversar. Y aquí ya quedan conectados. Bien, María José Jara, nuestra también miembro nueva de nuestro equipo, si pueden hablar rápidamente de ti, solo tu nombre, investigación, en español o en inglés, como quiera, María José.
Hello, I'm going to try in English. I'm very happy and honored to be part of this group, so thank you very much. Well, I'm María José. I'm a PhD student here in Chile, and my research is on children's rights and child protection proceedings. So I'm researching courts also, family courts. So, well, thank you for including me, and I'm very happy.
We are glad to have you here, Can you now, Marcelo, introduce yourself?
Hola, yo voy a hablar en español. Primero, muchas gracias por admitirme en el programa. Fue muy rápido el día de ayer, así que estoy muy agradecido a la disposición que hubo para incluirme. Yo soy egresado de Derecho de la Universidad Alberto Hurtado. Este año participé en el tercer Congreso de Derecho y Sociedad en la Universidad de Chile, en las mesas, pero también en la fundación de la asociación, finalmente. Y me interesó mucho la perspectiva de los estudios sociolegales o sociojurídicos en particular. Y en ese sentido, me interesa el estudio, particularmente me interesaba el estudio de el cruce entre la ciencia política, la discriminación, la desigualdad étnica e indígena, y ahora particularmente el estudio de etnografías institucionales, particularmente el estudio de ciertas cortes mediante el método etnográfico. Así que yo creo que este curso me va a servir un montón y por eso estoy muy agradecido por haberme incluido.
Muy interesante la investigación, Marcelo. Por eso está aquí. De verdad es un grupo bien interesante con distintas aristas de investigación. Y finalmente, Pedro Pachaguaya, si se puede presentar, Pedro, por favor, decir el tema que está trabajando rápidamente, un minutito, si no, Álvaro, que será el moderador de esta sesión, me va a matar.
Bien, bueno, muchas gracias, profesores, amigos, colegas, hermanos. Soy Pedro Pachaguaya, antropólogo de profesión, boliviano. Actualmente estoy en la Universidad de Tarapacá haciendo un doctorado. La temática que estoy tocando son cómo dos pueblos aymaras están implementando el pluralismo jurídico en el siglo XXI. Pueblos aymaras de Chile y de Bolivia, a partir de un estado donde efectivamente sí se han dado una implementación de alguna manera exitosa como Bolivia, el pluralismo y un proceso casi fallido en Chile, ¿no? Pero que tienen en común una serie de disposiciones internacionales que pueden ayudar a desarrollar esto. Eso es lo que estoy trabajando ahora y muchas gracias por invitarme y espero compartir muchas ideas y retroalimentarme con ustedes.
Gracias a ti, estimado Pedro. Bien, ahora voy a cambiar en inglés. Well, good afternoon, ladies and gentlemen. Welcome to our second session of the Chilean Law and Society program. My name is João Vitor Cardoso. Now I introduce myself. Now you know who I am. And I am the organizer of this program. And before I pass in the word to Álvaro Bartolotti, who is going to moderate this session, I just want to acknowledge that this program has a sponsor, which is Law and Society Association. And also, I would like to thank University of Chile for hosting us. And then just a couple of words of what drives this whole project. We want to hear different histories of how socio-legal scholarship has evolved in different countries. And we think it's really important to broaden our understanding of our field by studying different stories and different experiences of how law and social-legal scholarship evolves in different contexts. There's one dominant story of our field, namely the one by the US academia, There's nothing wrong with being aware of this story. On the contrary, as you guys have seen the first session, we engaged deeply with this story. But the next sessions, we want to show that there are surely many other stories of writing and searching in different social legal traditions. And these traditions include our own. We Brazilians, we have our own tradition. So I think in this session, with Professor Fábio de Sá Silva, we asked him for bring to the fore this this experience as an entry point to pluralize our vocabulary and our knowledge in social legal studies. But I just want to give a second message that this is a great opportunity for connecting scholars from all over, and also that another great opportunity for enhancing new views of social legal scholarship is social media. So I think social media can expand open access to scholarship and make the debate more inclusive. And this is why our program is accompanied by social media and a YouTube channel. I hope this becomes a very progressive room for horizontal networks. So now I want to pass the word to Álvaro, who is going to briefly introduce our speakers and moderate this session. Thank you very much.
Thank you, João, for that introduction. I would like to thank you also for the opportunity to be moderating. It is a privilege to be in the presence of these figures, Dr. Fábio de Sá and Dr. David Trubek. We all know they are pioneers on how we understand the subject of law and society. So if I were to enumerate everything that they have achieved and all their contributions to the field, I would probably be here talking during the whole session. So I will try to be as brief as possible while still making justice to both these scholars who have been so fundamental in the field of law and society. So Dr. Fábio de Sá is associate professor at the University of Oklahoma. He has been seamlessly blending academic rigor and policymaking. There has been over 15 years of influential work in Brazil's Ministry of Justice and the Institute for Applied Economic Research. Fábio has also been sought by institutions such as the United Nations and the International Bar Association. He is very widely recognized for his work, as João already briefly introduced, from Lava Jato to Bolsonaro and relational legal consciousness and anti-corruption, which has described the social political dynamics of Brazil's legal and political system very thoroughly. He has been continuing to build intellectual communities, co-directing the OU Center for Brazil Studies, and also serving as one of our speakers here today, joining, ingratiating us with his presence. Very briefly on Dr. Trubek, we've met him on the last session, but also again, very briefly, he is a luminary of these contributions. We have said him to be a legend in the law and society field in Brazil. He is a Yale graduate, former legal advisor of USAID. He has worked in many institutions from Harvard to London School of Economics. He has talked about critical legal theory, globalization, the role of law and development, and talking about emerging powers, international economics, etc. So, as I said, if I were to enumerate every single thing these two have contributed, I would be here all day. So you can finally listen to them talk. That's what we're here for. I would like to open the mic for Dr. David Trubek to briefly introduce some of the early efforts that were made to reform law in Brazil, and some of the events that from the 1960s when sociology of law in Brazil was beginning. And after that, we can listen to Dr. Fábio de Sá talk a a little bit about the challenges in empirical research on Brazilian law and society. So with no further ado, please, field is yours, Dr. Trubek.
Well, thank you very much. This is a great opportunity, as I tried to say in my probably slightly rusty Portuguese, which I haven't used for a long time and was trying to get back for this event because I had to do a lot of work in Portuguese. There's a timing problem. We had agreed that you would have a 5-minute introduction and we would have 55 minutes, and now you've had a 30-minute introduction. So you've taken almost half the time, am I right? Or 20 minutes anyway. So what are we going to do? Are we supposed to cut our talks back after spending hours working on them? Or are you going to extend the time?
We can extend the time. There's absolutely no problem. We can extend the time.
All right. Well, I've been in touch with Fabio. We could stay a little longer.
Mm-hmm.
So we'll see. Okay. Well, I just wanted to be sure because I appreciate the introduction, but I didn't want to make it a cause of cutting back my talk, which isn't very long anyway. All right. So as I understand it, you're interested in how sociology of law gets started and emerges and is supported, the whole sort of structure. And I want to talk about how legal education reform can be a force that either actually mandates sociology of law, or at least creates a context that's propitious for it. In Brazil, originally, legal education reform created conditions that were propitious for the early emergence of sociology of law, and that's what my talk is about. And eventually, as Fabio is going to tell you, led to making sociology of law a required course, which of course then made a huge impact on the field because it brought many, many people in working, teaching. Okay, so this is a play in 4 acts. The first is the developmental state. The second is lawyering in the developmental state. The third is a project called CEPED, and the fourth is the sociology of law. As I said, I actually was involved in these events. This isn't just history, this is personal reflection. The developmental state. In the late 50s and 1960s, Brazil underwent a massive restructuring of the state. It was designed to make the state an active instrument for economic growth. New institutions and agencies were created, and all sorts of incentives, fiscal and regulatory, were enacted. I did some work on fiscal incentives, and these were designed to modernize the private sector. As I wrote, I studied the new capital market law, which was designed to facilitate investment in industry and was regulated by a new agency. So all of that was new law aimed at a very clear developmental goal, in this case, increased investment in private industry. At the same time, the state expanded its own role in the economy and produced all sorts of services, electricity by Electrobras, telephone by Embratel, and so on and so forth. So you had the state regulating, you had the state providing incentives, and you had the state actually acting as an economic player. So this developmental state required a new kind of lawyer and a new kind of law. The new kind of law is obvious, dealing with trying to change things. bring about change in the economy and then manage and regulate the change that occurred. And a new kind of lawyer who could manage the new relationship between an activist state and fast-growing private markets. You had this very active state, and you had the market beginning to grow very fast. And a lot of what lawyers had to do was navigate between those two worlds. And of course, also manage the legal aspects of state activity itself. Well, it turned out there weren't a lot of lawyers with those skills in Brazil. And there were lawyers who recognized that there was a real gap between the lawyering that was needed and the lawyering that was available. And that's where I came in. So 1964, fresh out of the Yale Law School, I was legal advisor to the USAID mission to Brazil. And I worked on a lot of projects with Brazilian government agencies and private corporations, and I saw this lawyering gap. It was not hard to see. I could see that a lot of these lawyers just couldn't figure out what to do. So being a reformist, and that after all, I was starting my career trying to show the relationship between law and development, and this was in a very practical way, not a theoretical way. We needed different lawyers for development in Brazil, and we had to figure out how to do it. So what I did was look for a group of Brazilian lawyers who were at least partially committed to new ideas or completely committed to new ideas, and who had recognized the need for reform. And we sat down and said, you know, what can we do? How can I help? How can the US government help? We brought in the Ford Foundation as well. And the decision was to have a pilot project outside of the regular law schools. Rather than going and trying to reform one of the existing law schools, we felt that was premature because we didn't really know exactly what was needed and what would work and wouldn't work in the Brazilian context. And of course, if you started with an existing law school, at least, you know, a lot of people would resist you. And the last thing we needed was resistance. So we created this as a sort of a pilot and a kind of experimental space to create new ideas and test them out. So CEPED, the name of the organization, was created as an autonomous entity outside of the formal legal establishment, legal education establishment. CEPED means Centro de Estudos e Pesquisas no Ensino do Direito, which I figure even those who speak Spanish could translate, but it's the Center for Study and Research in Legal Education. And what it did was it provided, its main task was providing a one-year course on corporate lawyering, really, focusing on corporate lawyering, which included work for state corporations, for lawyers who were already in practice. So these were people who had already graduated from law school and were at least, you know, had a year, at least a year or two, and in many cases more, in practice. And CEPED was designed to bridge the gap between theoretical legal content and real-world legal practice. That was the idea. It served as a laboratory for what kind of methods and topics would do that. And the curriculum included social science perspectives on law and emphasized the social and economic role of law as a tool for development. It was explicitly showing how law could be used or was being used for development. and what that entailed in terms of the challenges to lawyers. And CEPED was, for its brief life, it only lasted 5 years, remarkably successful. It trained over 200 lawyers, of whom 14 got fellowships to go to the United States, one of whom we're going to discuss shortly, one of those fellows. By the way, I should point out that this was a lot of money. This was about $2 million. Now, $2 million may not sound like too much now, but in 1960, that was a lot of money. And that's how we were able to do all this. So what CEPED did was turn out a cadre of lawyers who appreciated this new way of thinking about law, appreciated the need for empirical studies on law, and quite a few of whom went into legal education. So that's part 3. That's the third act. That is developmental state, CEPED. And now we come to the sociology of law, which is what you want to know about. Okay. Now, CEPED lasted from 1967 to 1973, which is the time in which the sociology of law in Brazil really got started. And what the argument that Sophia and I make is that these two efforts overlapped and mutually assisted each other as they developed. Now, the earliest effort in the sociology of law goes back to 1960, when Claudio Soto gave the first Brazilian course on sociology of law in Pernambuco. He was followed the next year by Joaquim Falcão, who was at that time professor of sociology. The course continued, and Falcão and others helped form what has been called the Recife School of Legal Thought, which explicitly saw law as a possible instrument for development. Now, Falcão is the central figure in the story. And if you look him up, he's now an extremely famous guy in Brazil. So he did very well, including being dean of 2 law schools and all sorts of other things. And he was a pioneer in the development of sociology of law. He was the second person in the country ever to teach this topic. And as his career went on, he became a major supporter of the endeavor. Now, probably that'll come up in Fabio's discussion, because a lot of what he did was later than my period. Anyway, he was one of the early students in the CEPED course, and he must have been a very good student, because he got one of those fellowships and went to Harvard for a year in 1967. And when he came back in 1969, they made him a professor at CEPED. So here he was, having been a pioneer in the teaching of the sociology of law, and now teaching in CEPED with an approach that drew heavily on his understanding of the sociology of law. So you see, we have a law reform project built into it is an effort to integrate the sociology of law, because it fits into a vision of the role of law in development. Luciana Cunha has written a wonderful article, probably the best that I found on this particular period, and I know I've sent you the citation. She claims that there's what we could call an elective affinity connection between CEPED and the sociology of law, because, as she says, both see law as an instrument for the transformation of reality, and both see empirical research as the main form of knowledge production. And Fábio and Falcão was already deeply into empirical research himself, having done work while he was at CEPED and continuing it when he moved to PUC. So under Falcão's leadership, PUC established a master's program in law and development, the first course in Brazil to transcend the traditional divide between public and private law. It adopted a new curriculum for undergraduate courses, introducing economics and sociology, including the sociology of law. And there we are, legal reform and sociology of law. I'm not going to take it much further because we're now past my period, and I'm sure that Fábio will pick it up. But one final point is that in 1980, Falcão and Soto published a book on sociology of law that had a major impact on the development of the field. I hope that this is helpful and will get us going on what is a very long and very impressive history that Fábio has sketched in his paper.
Thank you so much, Dr. Trubek. Yes, this has been very helpful. Many of these things I had no idea about. I'm not gonna do much further. I just want to pass the word to Dr. Fábio de Sá, if you can hear us.
Buenas, muchas gracias, Álvaro, João, and colleagues here for the invitation. I wish I were able to travel to Chile for us to do this in person. It's been a long time since I last went there to Santiago which I did for my PhD dissertation research. It was a wonderful time that I spent there. And, it would be great to be back and to get to know more people. So my talk here is going to be based on this paper that I shared with João. Unfortunately, it's in Portuguese. It's called, Vectors, Challenges, and Possible Ventures. I think that's how I translated in empirical legal research in Brazil. It was published in 2016, so it's almost 10 years that I've written it. There's a couple of things that I might, amend or adjust if I were to write it today. But there's certainly a couple of things that I would add, considering the current moment. And I plan to spend a few minutes at the end just addressing those, new challenges for the institutionalization of it, what I call here empirical legal studies, which goes beyond sociology of law, because it might be in the interest of legal scholarship itself, and it might be in the interest of other disciplines besides sociology. So we have, for instance, political scientists who are doing empirical research on legal issues, right, that they incorporate into their own scholarship, as well as anthropologists and so on, right? And what I was trying to describe in this paper was precisely the development of this field, this very broad field that brings together all these different individuals with those different disciplinary backgrounds into a loosely organized community. And that's I guess part of the points that I wanted to make and stress here, because what I do in this paper is actually, or mostly, two things, and I'm going to focus on parts 1 and 2. The first is to map what I think are the structural forces that were at play in the institutionalization of empirical legal studies in Brazil, right? So what David is describing in his talk here, and he has written about this in many other spaces, is, first attempts to introduce a new way of thinking about law and doing law and studying law, right? That took place in the 60s, funded by the US government with his participation, but mostly in an experimental context, right? You have this small institution in Rio that tries to advance this. What I'm talking about here is a true turn, you know, that takes place more broadly in the country, that finds space in several institutions, public and private, especially public. And that doesn't happen, that leap doesn't happen by chance, right? You don't move from a few small experiments with a handful of people into something that's widespread out of nothing, right? You must have some structural forces at play here that drive this shift. That's point one. And point two is those structural forces, they have contradictions and they create tensions, right? This is, I think, what I'm trying to say in this specific part of the paper that I'm going to address with you. So, you know, I won't have time to go very deeply into each of them. You have the paper that you can read. It might be readable in Portuguese as it is. If you need to translate, you know, nowadays we have artificial intelligence or Google Translate that can help, right? But I think a lot of these topics here are also familiar to you guys in Chile because they are a common, you know, some of them are more unique of Brazil, I think, but some of them are more common to South American and Latin American countries. And I can see that when I hear, for instance, the kinds of projects that the students or scholars here in this workshop are involved with. So, you know, when Pedro talks about legal pluralism and right indigenous legalities, you know, that's something that's going to come up there in my talk. Or when Maria talks about, you know, gender, I think was it gender that courts and you know, courts and social change, right? That's also something that we're going to see in the Brazilian context that I will describe. So, you know, I mapped those 5 structural forces. The first one is what I call the exhaustion of legal positivism. We know legal positivism has a meaning that's more sophisticated. That's an attempt to make the study of law a scientific enterprise by you know, defining what the study of law is about, and that's defined as legal norms that are enacted by the states. And here there is a tension with other forms of legality, which makes it problematic already. But anyway, this is how legal knowledge has been traditionally defined, you know, at least since the 17th or 18th century. But there is a more, I guess, a gross meaning of legal positivism that's very popular in Latin America, which is this thoughtless reproduction of legal texts as if the knowledge about law were primarily or solely about knowing the legal text, right? This is also sometimes called formalism. Anyway, it's usually that model where you have a law professor that's also a professional, you know, that's an attorney or that's a judge or even a police officer, right? That comes to the class and just recites the content of the code, right? That was the dominant model of legal teaching and legal scholarship in Brazil. I mean, these comments, very superficial comments on legal texts became then manuals that were, you know, used as to support the courses, right? That was the predominant model in Brazil throughout the 20th century, and that's what made it impossible for Brazil to train those kinds of lawyers that David was looking for in the 60s, because, you know, they wouldn't know how to use law as a tool for anything, because for them law was an end in itself, so to speak, right? And there are many reasons why this paradigm enters a crisis by the end of the, I'll say 70s. including the fact, well, I mean, one of them was that it was deeply associated with the authoritarianism that the country was under. It was in the interest of the military regime to, confound legal knowledge with the knowledge of texts, because then people wouldn't, and students wouldn't invest inquiry into the deeper meaning or the fairness of those texts, right? And so when the military regime is losing traction and Brazil is moving into starting to make the move toward a democracy, of course, this starts to lose traction as well. But mostly it is, I think, the dissonance between the conflicts in society and the legal texts that really makes it visible, right? That legal positivism or formalism were not how legal knowledge should be defined. And along with this, there are many influences that are making their way into Brazilian intellectual circles, including from Europe, but also from the United States. So in the United States, you have critical legal studies that denounces, right, legal formalism and, legal doctrines as, for instance, indeterminate, right, and ideological. And in Europe, you have a whole, shift into toward more discursive understandings of norms that's going to drive the hermeneutic turn in, for instance, constitutional studies, right? That we're gonna develop a contact with. So that's one thing. So legal positivism, this thing that was predominant for decades in Brazilian law schools was losing traction. And the same people who were involved in the critique of legal positivism were, designing this reform in legal education. That was also very important. And David was mentioning here the fact that the reform made it mandatory for law schools to incorporate sociology of law, right? But what I say in the paper is that the reform was much more structural, right? There's a couple of things that they did. One was to also introduce as mandatory components a practical component. That's what opened space for legal clinics, for instance, which are very popular in Chile, right? And legal research. So students would have to develop their own research if they wanted to get a degree in law. And also I think the other part was this incorporation of non-legal disciplines into the legal curriculum, economics, sociology, philosophy, history, and so on, but in a very flexible way, so that schools would have the chance to build the curriculum as they saw fit by integrating both legal and, beyond legal knowledge, right? And that opened an important opportunity for experimentation as well, where the position of faculty who did empirical research was boosted within the schools because, there was a need or at least a chance for that kind of individual to succeed in the new law school environment. And then I talk about democratization, right? How democratization itself was a driver of a need for another kind of knowledge of law that was sensitive to what was happening beyond the courtroom or beyond just the codes. Because in democracy we have more conflict. Right? In democracy, we have open disputes about things such as gender, right? Such as race, such as the environment, right? How are you going to regulate economic activity so that it's respectful of nature, right? Which is a big issue in many South American countries. And also democracy, it opens a space for social movements. And that's another, I guess, force that operates here, which, you know, and social movements are trying to shape the law, right? That's one of the things that they are doing. So there's this incredible opportunity for studies that blend knowledge of social mobilization with legal change. And the only way you can capture that is through empirical studies, right? You have to go and you have to interview the people who are organizing. You have to look at their documents that they are producing or the other forms of intervention that they are developing, right? And so in Brazil, actually, there's this big movement that's called the Law Found on the Streets, that was precisely designed around this notion that social movements are agents instituting a new form of legality. And so that was also a very influential school of thought that gains traction in this period. Again, I think some of these things are shared among different South American countries, right? But maybe one thing that became more particular of Brazil was what I call here the pull of the policy audience, which was this need from, you know, forces that were within the state of knowledge about how law worked, which made them fund projects. And sometimes these are forces that are within the state. The National Council of Justice, for instance, became a funder of studies about courts, and they started giving grants for academics who wanted to do this kind of work. And again, that boosts the position of faculty who have the skills to do empirical research. But also we can find here, I don't think I stressed this enough in the text, NGOs, right? I mean, Ford is still present in the region, right? Fostering studies on human rights, for instance, that need to have that empirical angle to capture how law is working in real life. So, you know, the fact that we have now, and this is connected to democratization, we have this more open conversation about public policies, and the fact that in order to develop a policy, you need good information, also creates those opportunities for people who want to do and have the skills to do legal research. And lastly, globalization, because, you know, unlike in the 60s where you had these very unique encounters between scholars from the global north with the global south, you know, it had to be this project. It was a very well-funded project, but, you know, it was one project. Nowadays, we have the chance, I mean, this is what we are doing here, right? We are talking, we have people from the States, we have people from Brazil, we have people from Chile, all, you know, engaging in a conversation and exchanging knowledge about and perspectives about what law is and how law should be studied. And this is something that really makes an impact here. And I show in the paper, for instance, how Brazilians became more and more connected with the Law and Society Association, which is another sponsor of this series, but also with the Research Committee on Sociology of Law, in you know, which is part of the. Oh, okay. Sorry.
I'm sorry, what was that?
You can go on. So the
Okay.
internet is a little unstable, but we'll
My
fix it.
internet?
No, it's Dr. João's internet is not.
Oh, okay.
All right. But you can go ahead. Sorry to interrupt you.
Yeah. So, you know, globalization is really important here because it accelerates those exchanges. But as I was saying, one of the things that I try to do in this paper is also to show how these things, these factors have contradictions, and then how these contradictions lead to tension. I'm going to just mention two here. One is, you know, as knowledge about law becomes more important for different actors in society, it also becomes important to different actors in academia. So you have the anthropologists coming in, you have the political science coming in, you have the legal scholars, you know, who are already there. And they are all involved in this attempt to build a different type of knowledge based on empirical methodologies, right? But each of them wants to approach the phenomena they approach based on a different set of premises, right? So for lawyers, this is about prescribing, okay? So they want to study how, let's say, how criminal law is working, because their goal is to propose an interpretation for this part of the code, or, you know, maybe a legal reform that needs to be made through legislation to fix that problem, right? But maybe for an anthropologist, you know, this person is looking at the same set of issues, but they want to build a critique about, I don't know, how asymmetry of power between judges and lay individuals, right, contribute to the reproduction of certain forms of inequality, blah, blah, blah. And sometimes you can have tension between these different disciplinary perspectives. I guess a lot of us who do empirical legal research and we are at law schools, sometimes our colleagues see what we do as being non-legal. And so we have to justify what we are doing before them, because, you know, maybe we were engaging in those prescriptions, but maybe we are sometimes expanding our analysis into something that's broader, right? Anyway, the point here is that at the same time as empirical legal studies is an interdisciplinary endeavor, and that's what makes it cool, because you can tap on theories and methods of social sciences to do research on a legal matter. At the same time as it's cool to be interdisciplinary, it can also be conflictive, and it can also be troubling, right? And I'll just say a word about globalization, because I see similar tensions growing there. At the same time as it's cool for us to be in contact with developments that are taking place in the United States, with you know, perspectives, concerns, right? There is also a lot of times a pushback against what some global South scholars see as you know, a tendency to structure the field in a way that's hierarchical, and in which the perspectives and concerns of the global North are imposed over the global South. This is something that I've seen time and again in projects that I was part of, or in Law and Society meetings. There's always going to be somebody who's going to raise their hands and say, you know, this is colonialism, right? We would, you know, I don't see here a space for recognition of the knowledge that's being produced in the South. We've addressed this before, and you know, came to a different conclusion that I think is more critical, but this never gets to the mainstream, because, you know, global North institutions have dominance in the field, right? So anyway, the point here in this paper is to map those forces and to show the tensions that they potentially create. And I don't know whether these 5 forces are applicable to the Chilean context. This is something that I would like to, you know, hear from you, right? So maybe you are experiencing that kind of globalization, right? Your field of law and society, empirical legal studies, law and development studies, however you call it, is being benefited more and more by these exchanges with the global North, right? With LSA, right? But maybe you don't have a legal reform, a reforming legal education of the kind that Brazil had, that really created more space in law schools for this kind of knowledge to be produced and legitimated. I don't know, right? This is a very particular history. It's by no means generalizable even beyond the Brazilian context into the South American context. But if you didn't have something such as a reform in your law school curriculum, what is it that you had there that is enabling, right, that kind of the growth of that kind of empirical legal research? I read a paper, I remember, that was published in Law and Social Inquiry about Chile that actually argued that neoliberalism helped develop law and society studies in Chile. And why is that? It's because Pinochet, started this model of giving grants, competitive grants to universities, right? In order to promote meritocracy, in order to promote, those neoliberal values. And so, but that also meant that all of a sudden you had all this money that was being given by the federal government to research, which traditional legal scholars, for instance, didn't have the ability to tap on. And so you had these faculty who had, interdisciplinary training and who maybe came from political science where they were already used to applying to those grants and so on. And they started getting those grants and they started building these centers of excellency in some Chilean law schools, right? I think the challenge for you is to, and maybe that's where the contribution from this paper comes, is to map what is enabling and what is constraining the development of social legal research in Chile, and what kinds of tensions is that potentially creating that you have to know how to manage. I guess that's a good, place to stop and maybe turn the word back to you and listen to you and make this more of a joint reflection. Thank you.
Thank you so much, Dr. Fabio. Just wanted to say, if the students have questions, they can send it through the chat. They can be in Spanish or English, and we can translate it.
Alvaro, I'm going to have to step out just for a couple of minutes because I had set something up at 12:30, but
Okay.
I'll be back in 5 minutes, in less than 5 minutes, okay?
Okay. We'll wait
Now,
for
how
you.
do I close I don't use this system.
There
How
should
do
be
I?
a leave button, a little
There
button.
are two buttons. Do you know where you mute yourself?
Yeah, so, okay, so if I say stop video,
Yeah.
that's it.
Yeah.
Got it, okay.
Mute yourself and stop your video.
Oh, yeah, mute myself. I might.
There.
Thank you.
All
right.
All right. I
Buena.
think you had, I thought it was very interesting what you were talking about the epistemological differences of the field, right? I mean, it's.
And just one, if you want to move to Spanish, it's okay.
Okay, well, I mean, I can do Portuguese or Spanish or whatever is more comfortable. I think it's better in English because when other people see this, since being recording, I think it might be better.
I see.
Yeah. So apologies for that. It's just that's actually a little bit of the part of the question that I had, because things that you mentioned, some of the epistemological challenges that different areas are when addressing the field. I guess one of the challenges of any field when it's new, when you're pioneering on it, is that there's not a lot of guide. There's not a lot of knowledge about how to go around these things. And one of the great difficulties for students, particularly in the global South, is that most of these things are produced, like you said, in the global North. Even when they are produced about the global South, they are produced in the global North. So when we're thinking about like the people who are young scholars who are trying to publish or trying to be recognized, but then maybe because of some editorial choices or maybe because of an epistemological differences, maybe journals won't accept it or they just won't even read it. So what would you say are some of the challenges or advices that you would have for these young scholars who are trying to strive on the field? I hope it's not too hard, of course.
No, that's I'm laughing because this is a I don't know for how long I've been thinking about this, because it does require for a young scholar, especially if you're, in my case, I moved from Brazil to the US, right? And I needed to publish in English and in top US journals to get my tenure there. So I had no choice. I had to tailor my scholarship to the taste of these journals which is mostly controlled by US scholars, right? And this is something that I've said in many meetings of LSA, for instance, where we had some roundtables about, you know, how to get published. I would make this point. And, you know, some journal editors, I think over time, they started acknowledging this. And so one thing that I'm seeing now is that when they look for reviewers, they look for reviewers from these countries that the papers are about. And they are requiring more and more that you cite scholarship that's produced in those countries, which I think is great. Very recently, and this is something that I have a small part in because I was, you know, this came from a conversation that I had with the editors of the Law and Society Review. They are granting translation rights to the authors. So you can have the same paper that you publish with them in English translated into, let's say, Spanish or Portuguese. And they're going to publish that as well. So that makes your work more accessible, because I think one of the issues behind what you're asking is that, you know, sometimes not only is our work disconnected from the concerns that are predominant in the Global South, because they have to speak to the concerns that are predominant in the Global North, but they are not even read by Global South scholars, right? So Global South scholars don't even have a chance to engage and to maybe oppose those arguments if they want, because there are the paywalls, you know, it's an expensive system, right? At least the language barrier there now starting to lower. So I would say, on one hand, you have to play the game. On the other hand, you have to try to change the rules of the game as you play it. And so, you know, when I write, I engage with the frames that are predominant in the Global North, but I also always try to bring some elements from the Global South to the discussion. And I think as I've learned how to do that, my scholarship has become more and more, you know, well-rounded, but also appealing to some Global North people, because then they start to see that I'm going beyond where they can go, right? Because they are attached to their frames, and I'm bringing something new, even if it's marginal, you know, but it's something that they were not seeing. So yeah, I don't think I have an answer that's satisfactory to this, but it's really something that you have to work through as you build your identity as a scholar who, you know, move between the two contexts.
Thank you. That was actually very helpful. I think the rule is, like you said, play the game, and in general, collaborate. That's one thing that we started to learn from an early time, is that if you don't collaborate, you have very little leverage. You have very little ways to do things by yourself, especially when you're starting your career, right? I guess Joel and Dr. Trubek are back here. Do you guys want to weigh in the debate here about these challenges for Global South researchers and publications and rules of journals, etc.?
Oh, I think, wait a minute, you want me to comment on that?
I mean,
If
if you would like to, or if you want, we can move on to something more.
Well, I would say that, you know, Fabio, he's got it all. I can't add, and I've been less in touch with things. I haven't been that active in the Law and Society Association for the last few years. So I think I think there is a problem. I did want to make one comment about globalization. You know, from my point of view, some of you are young enough so that you think it's there, just part of life. But for me, it's just an unbelievable transformation in the possibilities of scholarship. Yesterday, I got email messages from Falcão in Lisbon, from Fabio in Brazil, from Sophia in Brazil, and 2 or 3 others. Oh, from Octavio, who is in London. just in one day, right? I mean, this is unthinkable. Even 10 years ago, it was unthinkable. And now, it's just the sort of thing you do. So you're in a new world. And yes, I'm sure there are problems, global South versus global North, but I think we're moving in a positive direction. I think the Law and Society Association, the very fact that you're getting funded by them is a sign. And one of the things since the Law and Society Association came up, one of the problems that I had in doing this is, what is the sociology of law versus empirical legal studies or law and society? Because and I don't fully understand in the Brazilian context, Fabio, or in the minds of the people in Chile, what's in and what's out of the sociology of law. And I sort of struggle with that. I'm sorry, I'm going to have to take this call.
João, you want to go next?
Yeah, okay, folks. Professor Trubek is answering a call. Now, I want to hear Professor Fábio about the current trends we have in social legal scholarship in Latin America, and there has been a lot of debate within the Law and Society Association about some concern about this concern for the progressive social, the idea of progressive social change. Like, Law and Society is some of leftists. The leftists, of people who are increasingly embracing postmodernism within Law and Society scholarship. So, on the one hand, we have this concern with progressive social change, embracing postmodernism, and on the other hand, you have the backlash. And in what ways this affects your scholarship, and if you could illustrate with some example of your own scholarship, how this debate affects social legal scholarship today.
That's a good point, because I wanted to, I forgot about this. I wanted to end my, initial presentation precisely with some comments on current events and how they are, I think, affecting also the prospects for empirical legal research or social legal research. So, but maybe just say a few words about this, since they've raised the reason why I framed the paper in the talk, and I usually talk about empirical legal studies when I refer to the Brazilian cases, is because that's how they named themselves, right? You have the Rede, the Network for Empirical Legal Studies, and it's a community that congregates people from different disciplines besides sociology. So political sciences and anthropology too. So I think it's closer to Law and Society than to what in the US is called empirical legal studies, which is more of a quantitative approach to legal issues, right? You have the Journal of Empirical Legal Studies in the US, and I think there's a Society for Empirical Legal Studies that's more kind of, economists of law, sort of. But anyway, I agree. It's and as I said, it's a very loosely organized community. But João, I think one of the challenges I see in legal empirical legal studies, law and society scholarship nowadays, is precisely the declining status of expert knowledge in general, right? I mean, if there's one thing that we claimed we were doing by introducing empirical methods and, critical theory into law, was to show how law actually works, who it benefits, who it doesn't, right? Behind this facade of fairness and, justice and equality that law uses to legitimate itself, you might have very, very, gloomy things happening, right? And this is what we like to illuminate, but it's become difficult and sometimes dangerous to illuminate those things nowadays, right? And the election of Trump in the US, and strength of the far right in the region, right? In Brazil, in Argentina. I think all these things put us in a difficult position. I mean, on one hand, we are not seen as credible subjects, right? We are called the ideológicos, right? Because we are denouncing those inequalities in terms of gender, race, and we are denouncing, the impact of business on the environment and indigenous people and so on. And we are often seen as, part of the woke movement, right? To the extent that we do these things. So it's become difficult. I like your question, Ron, because I think, and this is what my friends say to me, and this speaks to the question that Alvaro also raised before about publication. My Brazilian friends say to me that I became more conservative after I became a scholar in the US, publishing in US journals. Because we indeed come from a much more radical tradition, and from student movement and in radical postmodern thinking, right? That's how I was socialized into law and studies, right? And then as I begin to fit into the law and society community, this is what they say to me. I became more positivist in my epistemological thinking, right? And I became more conservative in my political values. I'm my scholarship nowadays is in defense of liberal democracy. I grew up with people who wanted to replace liberal democracy with actual democracy. So it's difficult because on one hand, I'm seen as more conservative by my South American friends, but on the other hand, I might be seen in the US or by the far right in Brazil as a radical. So it's a difficult space to occupy, to be in.
Let me just take one from here, Alvaro, and make a quick question to Professor Trubek. And you said you explained how back then in the 60s, this CEPED and the Brazilian law program were developed back then. So, there was a very similar program in Chile, the Chilean law program, which actually was launched a year after that one. And there were some people trying to institutionalize some efforts to create a social legal scholarship with a Chilean mark in it, but I don't know. It seems like if you read James Gardner's book in Chile, it seems that this program was viewed as a vehicle of imperialism. Actually, the book is called Legal Imperialism. So you had Chile was like the case study of James Gardner's book, through which you would find how these ideas of creating legal clinics, however, is just advertising it there. It's such a great book. And if you guys haven't read it, you should buy it because it's getting ever more expensive. And there are a few copies left on Amazon. But well, so you had this idea, Professor Trubek, of implementing the case study method, incorporating social science to the curriculum. But then in Chile, it actually, I think the diagnostic we are starting to make here, it failed. And why the failure? How would you explain that? Because actually the Law and Society project never gained the level of institutional support needed to bear fruit here in Chile. While like in the paper, Professor Fabio shows that how much money, how much funding were actually invested in Brazil by institutions in order to develop a very like refreshing network of law and society there, and that haven't happened here. Could you give us like some words on Chile also, if you remember who were the people who were in charge of the Chilean law program, how this was related to the Brazilian law program which you were heading. So, and the second question is that you've been the editor of many reviews and journals. If you could please, you guys in the North are always saying that you are trying to reach out to scholars writing in the Global South and encouraging submissions. But it's actually not that easy for us. Sometimes our articles are not even, don't even go through the admission phase. So if you could like do a like a very like fast food workshop on how to publish in these journals, that would help a lot.
Well, one question is too close to this time, and one is too far away from this time for me to be able to answer it without having time to review. I'm sure I knew, I'm 89, and my memory is not what it used to be. So I can't really tell you what the difference is. It seems to me, though, that this is your question. We have given you quite a bit of information about the Brazil experience, the paper that we sent, 15 articles, that almost all of whom at least mention CEPED, and some discuss it in some detail and talk about legal education reform. So I think that I'm going to throw that back to you and say this is a Chilean issue. I wish I could be more helpful. On the question of journals, I think Fabio spoke to this, and he's much more in touch with, I haven't been involved in this business for, a decade at least. So I don't want to, weigh in any way to contradict what Fabio said. I know it's a problem. Fabio he identified the problem. I think that bringing it up in meetings like the Law and Society Association meetings, perhaps getting, developing some evidence that would actually show patterns, if you can do that, of the difference between who gets accepted and who doesn't based on their geographic location. If it's possible to get that data, that would have a tremendous effect. And get it on the agenda at places like the Law and Society Association. I think that the majority of people in the Law and Society Association, if they were given credible evidence that there is a bias that is strictly based on geography and not on quality, they would consider that something worth paying a great deal of attention to. Now, being able to do that is no simple task, because I think that part of the problem is that there are these different academic practices and traditions. And so what is going on is not a necessarily geographic prejudice, but a clash of what people think of as the essence of scholarship. What do you think, Fabio?
Well, I agree, and I think maybe 60 or 70% of the work that is involved into getting published in one of those journals has to do with adapting the content to the genre that reviewers are used to. And I've seen Brazilian scholars who have mastered that, and they get 1 or 2 papers published every year in US or UK journals. And I've seen, fantastic Brazilian scholars who can't get published elsewhere because the way they write, the way they structure the argument is not doesn't fit the expectations, of these editors. I know there are some efforts by LSA, for instance, to do workshops, writing workshops. One of the things that I think they funded through these global grants was a workshop, a writing workshop to non-US scholars. I think that was maybe in Africa. And yeah, I mean, ideally you had to work with somebody or spend some time, in an institution where you have the chance to, for instance, write and share a draft and get feedback, and then learn through trial and error how to properly structure an argument so that it will sound, or it will read in a way that's familiar with the templates that these reviewers and editors are used to. I don't see a better way, that's how I learned. It was by submitting and getting rejected and then getting the feedback and then realizing what mistakes I was making, But again, the idea of what's right and what's wrong here is a social construct, right? I know that there are some papers that I can write, they're going to be published in Brazil, no matter what. That I don't need to adapt to any extent. But if I want to publish them in a US or UK journal, well, we'll need to change the structure and basically have introduction, literature review, what is the gap, what's my evidence, argument and evidence, and then conclusion, right? That's if you can't make your story fit that kind of structure, you're already in trouble when it comes to your chances of getting published, And again, sometimes it's just a matter of having this in mind as you write, more than anything. I mean,
this is a little new to me. The nature of this. I totally understand now that I hear it. It just hasn't been something that I've been personally engaged in. But I have a suggestion for you. It seems to me that one thing you could do, that is the Chilean group, is to communicate about this problem to the people who gave you this grant. Because you could say, look, you're encouraging us to set up a center here, a program, whatever this is, but and become part of this global community. But there's evidence that the global community isn't an equal community, and that there's a big problem with scholars in countries like Chile getting published in the international journals. And so in a way, you could be setting us up for disappointment, so that if you're really serious about the expansion of the Law and Society movement, you should be looking at this question and thinking about how to make things easier, either by more training for people from Chile in how to follow the current structure in these journals, or the journals becoming a little bit more Catholic in their methods, or new journals explicitly for this purpose. So,
Yeah.
so throw it back to Law and Society and say, hey, if you want to have an active program of expanding the field globally and into the global South, you've got to think about how to deal with this issue, as well as, how to set up the headquarters in Santiago or whatever. So that's my final suggestion, and I think this has been very useful. And I'll tell you that it's going to have extreme practical consequences for me, because Sophia and I are going to write this paper up as an article to publish, and we're going to take account of the fact that, even with my name on it, it's going to be her article coming from the Global South, and we better be sensitive to the issues. So we'll probably have to consult Fabio when we have a draft of the article. So you see, you never know what's going to come up. This was great, and I hope that we were helpful. I think you've got a great project, and if I can be of more help, let me know. But I do have to go now.
Thank you so much, Dr. Trubek. Yes, we understand. We went a little bit over the time. So I guess, does any of the students, anyone wants to ask any other questions or raise a debate with Professor Fábio de Sá? Maybe ask for some more advice. And if not, you can always reach out to us in our emails. We have a reading list that we can share with you. João, I don't know if there's anything else that we can discuss.
Yeah, just like a couple of words, and if no one wants to take the word here, and anyone has any intervention? Professor Agustín Barroalé is here with us right now, and I don't know if he has something to add to this issues we've been discussing now.
I arrived very late, and I apologize for that. We had an emergency here at the office, so I'm just hooking up. But I heard some of the answers Fabio gave to the problem of not being published in journals outside the U.S. in empirical and non-society. And I believe I said this in the previous meeting. I'm analyzing all the research grants granted by our ANID, our research agency. The ones that we usually apply to, you know them well, Joao. So only 8% of the fundacids on our coding fell into what we could call somewhat empirical, most of them qualitative, and just two of them, three of them, one actually mine, was quantitative. So that tells you a lot of how even the funding is playing a role in what things what gets researched. Which I think is pretty bad, because if we are gonna get people that from the Law Society to be in one of those committees that end deciding which are gonna be the peers that evaluate the projects, then it will be a really, really hard road. It will be really up the hill. So that's that.
You know, Professor Borrale, Fabio's paper, which we've discussed today, has a very interesting approach on how to study how funding in empirical legal scholarship evolved in Brazil. And I don't know, Fabio, if you could like explain your decision, your methodological decision. How did you like? You did not. You did the opposite to Professor Barrolet. Actually, what you did, you didn't consider. You've not considered the FAPESP, CNPq. You consider other factors that could be of help for Professor Barrolet, maybe, if you explain what you did.
No, if I remember well, I think the main point there was to say that there were more diverse sources of funding, and a lot of them linked to public policy rather than to, pure scholarship. So that's why I included the National Council of Justice, which was supporting a lot of empirical studies on courts. The Minister of Justice, they had a program there called Pensando o Direito that was dispensed a lot of money to empirical studies to evaluate legislation, the effectiveness of existing legislation to be able to propose changes to Congress and that kind of thing, in addition to the CNPq or FAPESP, the more traditional sources. So I think the point there was that, and a lot of those, well, essentially, they always wanted an empirical component to that, and a large data set. So that really propelled, or at least supported extensively empirical legal studies. So maybe that's a difference to consider, right? When you have an entity that's interested in policy or in findings that are policy relevant, it really needs to be empirical, right? And if it has a quantitative component, the better, right? If you can draw basic statistics to show distribution of lawsuits, right? Over time, for instance, which they have no idea what it is. And where they need to invest their resources, right? So maybe that's one factor to consider. If you bring the policy people in, they are going to give a push for more empirically grounded research. But on the other hand, there begins to be a tension between the policy people and the academics, because the policy people want academics to respond to practical questions, whereas academics a lot of times want to develop, structural critiques of the phenomena that they're looking at, right? So again, it brings me back to my basic points that you have these structural forces, but you also have the tensions.
So if I can react to what you said, Fabio, so I would say Chile is in a earlier stage of development. Some institutions are building more serious databases, which I assume will end in some empirical study at some point. That there are two things that seem unique to Chile, given Brazil's case, that it would be worth mentioning for all our students here. One is the fact that basically commercial engineers and the influence of Chicago, that profession took over the policy debate long ago. As my colleague Cristian Villalonga has written from the Universidad Católica, Cristian has shown how the legal profession retreated from the administration and public policy after the military regime, and therefore the commercial engineers took over policy and sidelined a lot of what was used to be a part of the legal profession and legal work. So that's a huge, I think, development that has preempted lawyers moving more into empirical stuff and policy questions. Actually, it's really hard to find lawyers that are trained in some empirical methods. So my co-authors are all from the economic law schools. And the second thing is that, at least in my law school, and the ones I know here, Francisca's, Joao's, and I would dare say at least the 25 largest law schools in Chile, they have this metric that they qualify, they rate and rank researchers according to how many of these traditional grants they get. So you might get the money for a non-traditional research, more empirically focused, that it doesn't give you points to get traditional funding, and doesn't give you points with your own school, and it's kind of it's what everybody's doing. They're competing on getting more and more of these traditional grants, and so that when you want to go empirical, unless you're going to do what I did, which is try 5 times and then change the project to English, and then try to make some American peers to review it instead of Chilean scholars, you have to do it on your own time with your own money, basically, which is somewhat sad, but completely true.
That was a great, I think this is a great insight to end up with. So I don't know if anyone has any more questions, but I think we should get going from here. We're a bit late.
One last thing. Somebody asked for a reading list on the. Just to reiterate, if you can email me, me and João can put together a reading list about these subjects and send it to you. Suggestions of books. João is a little bit of a bookworm, so he has all the books in the world. He knows them all, so there's absolutely nothing to lose from asking him for readings.
Don't exaggerate, please. But well, just want to say I am really very happy we managed to bring these people here together. I mean, to connect people here to this network, and say that we are connected now. We have a lot of important projects here, which are we are trying like to pull strings together and find somehow to create the first like Chilean Law and Society network. Maybe we could like connect it to over in the US and create the Red Latinoamericana de Derecho y Sociedad, which is something we are looking forward to do, and then we're going to institutionalize it there in University of Florida, and so that would be a great goal to pursue. But just want to say we are very grateful, Professor Fábio de Sá e Silva, for your patience and your help, and just want to acknowledge once again Law and Society Association for funding this initiative, and say that this project is permanently under construction. So if you guys have any suggestion, we'll be very happy to listen to it. And just thank you very much. And to quote Bad Bunny, that's all, folks.
Valeu, João. Muito obrigado aí.
Invite your friends the next time. We're there. Like, bring a friend.
Gracias a todos. Um abraço. Tchau, tchau.
Gracias.
Hasta luego.
Gracias a todos.
Parabéns, Fábio. Obrigada. Até logo.
Obrigado, Priscila. Tchau, tchau.